So how many of you are students? Raise your hands. Okay.
Yay!
All right. So this panel is going to talk about how we can incorporate critical race theory into clinical legal education. And so I want to start by saying that modern legal education occupies, clinical legal education within modern legal education occupies a unique place. It strives to ensure that students not only get the practical skills they need to be lawyers, but to also imbue them with certain values and to improve access to justice as well. So clinical legal education is differently situated than doctrinal classes in that it has this teaching goal and this access to justice goal. From its inception, modern clinical legal education was actually situated within the academy as a reform movement. I think it's fair to say that there has historically been some resistance or apathy to clinical legal education because it upsets the traditional methods of instruction and actually seeks to transform the content and methodology of legal education. It seeks to transform both what we are teaching students and how we teach it. And so some of the reformation goals of clinical legal education included things like helping students to develop an appropriate professional identity that enables them to practice with purpose, allowing students to see firsthand how the law and legal systems actually operate in the lives of real people, not just the synthesized facts in an appellate case that you might read in your casebooks. And helping students to learn to see the law as an interpretive project, and allowing students, of course, to develop lawyering skills. Effectuating these goals, however, requires a different kind of pedagogy. For the students in the room, how many of you have taken a clinic or are going to take one? Okay. So to understand where we're going to go here today, you have to understand how clinical legal education differs from traditional doctrinal classes. Clinical pedagogy incorporates a combination of a seminar or classroom component, field work where students actually represent real clients, people and or organizations, and it also has small faculty supervision sessions where you meet with your supervising faculty member in a small session and you have very intense instruction that way. In the seminar or course portion of the clinic, students learn lawyering theory, and the lawyering theory provides a conceptual framework to help them do their field work. I like to tell my students the lawyering theory that we learn in seminar class is important to help you think like a lawyer in a practical way. You hear in doctrinal classes, we're teaching you how to think like a lawyer, but in clinic, the lawyering theory, you actually get a chance to practice it and see if you want to buy or sell the theory, as I tell my students. The seminar also introduces the students to a normative vision of the lawyer's work. What does it really mean to be a lawyer? What does this look like on a day-to-day basis? What values am I bringing to this? What's the good? What's the bad? It's also a space for students to explore broader questions related to the role of the law, both in structuring inequality and in achieving social justice. The small supervisory sessions provide a chance for students to receive guidance on their casework, to obtain feedback, and to critically reflect on the work they're doing. So while clinical pedagogy is not traditionally seen, though, as a place for critical race theory, this panel, however, is going to talk about how and why clinical pedagogy should be seen as an appropriate, if not necessary, place for critical race theory. Of course, at this moment, CRT is under attack, and it may feel somewhat odd, dangerous, or even counterintuitive to be proposing that we incorporate critical race theory into clinical legal pedagogy. It's fair to say that clinics are not at all insulated from scrutiny or attack. I might argue that clinics are actually in a more precarious space in terms of potentially coming under attack for the concrete work they're doing in addition to the conceptual frameworks that we are using. The current university's administration's approaches to withholding federal funds, for example, for any faculty member or any project that's seeking to do racial justice work that seeks to end subordination, that challenges colonization or imperialism, makes a challenge to think about incorporating critical race theory into clinical pedagogy. I want to submit to you here today that it can be done. It can be done in a way that is smart, strategic, and bold at the same time. I would also submit to you that students now more than ever need critical race theory as part of clinical legal pedagogy. CRT as part of clinical legal pedagogy will help students make sense of and navigate what it is that they are seeing. These frames more than ever are necessary now to help students make order of what they're seeing. Also, to the extent that clinical legal education began as and continues to be a reform project that's in some ways antithetical to some of the traditional values of legal education, it's important to incorporate CRT into clinical pedagogy, as that is consistent with the goals of clinical legal education. Most importantly, incorporating CRT into clinical pedagogy can help students think creatively about the most effective modes of advocacy at this moment and the role of lawyers at this moment. So for these reasons, engaging CRT within clinical pedagogy is not just a good thing to do, it's actually an imperative. So despite the moment and the challenges, what we're going to do here today in this panel discussion is talk to you about how we have incorporated CRT into clinical legal pedagogy. And so I am going to go first, and so I'll start by saying that I used to teach a civil legal assistance clinic, and around 2019, I decided that it was imperative to figure out how to incorporate critical race theory into what I was teaching my students. So I founded this new clinic called a critical race lawyering clinic. And so I want to explain to you what we do and give you an example of, a specific case example of how CRT frames were very helpful in litigating this case. So the critical race lawyering clinic begins in a non-traditional way for a clinic class. I actually start my clinic with a 2-week intensive critical race theory boot camp. And within the critical race theory boot camp, students are introduced to the origins of critical race theory. They're introduced to the nuances of the contestation between critical race theory and critical legal studies. They are then introduced to some of the basic tenets of critical race theory. So I will submit to you that critical race theory can't be distilled into simple tenets, and that people agree, disagree with some of the tenets, but I like to give my students this baseline of tenets that I think many critical race theorists can agree with, being that racism is ordinary, not aberrant, that race is a social construct, that there is this differential racialization, intersectionality and anti-essentialism, interest convergence, and the idea of centering the voices of people of color using counter-narratives. And so students are immersed in this for the first 2 weeks. Unlike other clinic classes, we don't touch interviewing or skills or anything like that until we go through the critical race theory boot camp to give them a solid doctrinal footing. And so I want to give you an example of how this doctrinal footing came to be very helpful in a case that we litigated called Schaffner v. Bigelow. And so I'll say at the start, this case went all the way to a damn jury trial in a place called Alamance County, North Carolina, which if you Google it now is notoriously has a very rife racial history, to put it nicely. And so the gist of the case was that Ms. Dewana Bigelow, a black woman, was running to be the first black person on the city council in a town called Burlington in North Carolina. And so this was during the summer of the 2020 protests for racial justice, and at one of the protests, Ms. Bigelow was there, and there was a huge counterinsurgency of Confederates, literal Confederates, who were there in opposition to racial justice, that were waving Confederate flags and a bunch of other things. And at this, among the counter-protesters was a nurse who said some very unfortunate things about letting black people die if they were going to be out in the street protesting for racial justice. So my client reported what this nurse had said on social media. The post went viral, and the nurse ended up getting fired from her job because people called in to complain. So the nurse sued my client for defamation. So place number one where CRT came to be very helpful. We are a civil rights clinic, and we decided to take on a defamation case, which is not a civil rights claim traditionally. And so as part of the litigation, one of the important things to get the students to understand was the way that race was operating, not just in this moment, but historically in Alamance County. The desire not to have this black woman on the city council was huge. The local media sources actually publicized every single thing that happened in this lawsuit. It got to the point where opposing counsel in the case would file a motion to compel for every single set of discovery that was propounded on us, and then he would put in all this extraneous information in the discovery, and the local newspaper would use the discovery responses to report about what was happening in the case. So this was not a usual case. But the challenge was getting the students to understand that this wasn't a usual case. The students' first inclination, despite the critical race theory boot camp, was to litigate this as a pure defamation case and minimize the discussion of race and lean heavily on truth as a defense, that we had witnesses who heard her say the things that my client said that she said. So what I ended up doing is relying heavily on two particular tenets. The first is this idea that racism is ordinary, not aberrant, this idea of racial realism. And so in relying on that tenet, I asked the students to step back and take a look at facts that they might not consider relevant to the litigation. They wanted to focus myopically on the protest, what was said, and who heard it. So I implored them to think much broader than that and to think about the history of Alamance County. So I had them doing historical research on the history of Alamance County, the history of the Klan in Alamance County, to better contextualize what was happening and why they so ardently did not want this woman on the city council, and to understand how the lawsuit was part of a ploy to sully her reputation so that she would not win the city council election. So I also had them think about how we were going to tell counter narratives to the traditional version of race that was prevalent in Alamance County. And I also had them think about the lived reality of black people in Alamance County. So I had them not just interview the people at the protest, but people who lived in this small community, who could give them an example of their lived experience in Alamance County and why they also thought the lawsuit was a ploy to not get her on the city council, and to contextualize the power dynamics, the way that the media was operating. I had them do research on the Alamance News and what they've traditionally done, and so this was very helpful, using this frame to make them zoom out and to really dig deep to understand how race was operating. And so I had them then begin to understand how the defamation claim was not indeed race neutral, and to consider the way that race, gender, and geography were operating in this context. I incorporated critical race theory literature as part of the seminar, in addition to the skills, in addition to the critical race theory boot camp, and they were so hyped up about it, they actually found this article from the ABA, which made them think I was the smartest person in the world, because the article was talking about how a recent span of libel cases, people suing people who accused them being racist, was being used as a wedge to undercut the power of people of color in social media. And so some of the readings that I had them do was whiteness is property, adaptive discrimination by a least body, some readings on the First Amendment from Words That Wound. And then the other really, I think, important place that CRT came in where I had them use counter narratives in places that most litigation people would tell you, maybe that's not a good idea. We upended it. So as an example, in our answer, so this is a snippet of the original complaint, and you can see the plaintiff's lawyer framed it as very lawyerly, that his client was opposing the call to remove a Confederate monument at this protest, and that my client attended the protest and supportive removing the Confederate monument, and that lacked a lot of nuance and context. And so usually the way that you would answer that complaint is admit, deny, admit, deny. But we decided to go further and give our side of the story and to really build the counter narrative about how race was deeply embedded in what was happening here, to highlight the racial dynamics. And so we did this kind of narrative setting not only in the answer but in discovery as well, and interrogatories and requests for production of documents, knowing that Alamance News was going to publish everything. So we were setting the scene that way. And so what ended up happening as we won, we actually won a jury trial, and during voir dire, it was interesting because a lot of the jury pool admitted to reading the Alamance News, which was our goal. If they were going to use it that way, we're going to use it as well. And they couldn't strike everyone who was because it was such a small community. So after we won the jury verdict in a case that was like To Kill a Mockingbird, Ms. Bidwell ran for city, won her race for city council. And then the last thing I'll say is we also engaged in critical reflection. So even though we won, and this was a big deal, the way that my former law school printed it up was about the First Amendment issues and not the racial justice issues. So I also have them reflect on what it means to use this critical race lawyering and what opposition might look like, and what it, especially when you are a part of a larger institution that might not be as committed to critical race lawyering, and we have them think about how we may counter the university's narrative of what happened. So we wound up teaming up with another org called Emancipate NC, and they did another bigger story that embedded the race issues and not just the free speech First Amendment issues. So a little over time, but that is my
I'm going to take facilitators for us and start on that end. Which way? Look down this way.
I talk from here. Because I have no slides, so I don't need to go to the...
No, you can speak from there. That's really fine.
Nice. Hi, everyone. It's really...
Also, I think we should all just introduce ourselves
Yes.
before we speak.
I will do that. It's really good to be here. I'm really honored to be on this panel, in particular, in a conversation with these brilliant ladies. I am Annie Lai. I direct a clinic called the Immigrant and Racial Justice Solidarity Clinic at UC Irvine. Up until this summer, July 2025, it was called the Immigrant Rights Clinic, and was founded by Samir Asher, a colleague of mine, who now directs a different clinic. We taught together for a number of years, and I think that transition, so that folks kind of understand it a little bit more, took a few forms. One is that now with the name change and the clinic focus change, we are situating immigrants' rights work explicitly as a racial justice issue and looking at it through racial justice lens. The second is that we expanded the scope of our work, so we're still doing a lot of immigrants' rights work, but also doing some work around implementation of the California Racial Justice Act and our criminal legal system, partnering with Public Counsel, which is an organization here in LA, to advise nonprofits on responding to the administration's attacks on DEI and the various executive orders. And we have an affiliation with the UCI Law Korematsu Center, so Rob and Julie are here, and we had an opportunity to collaborate as well, which is really cool. I firmly believe, I think there are a lot of ways to articulate the goals of clinical education, but I think that I firmly believe that we're kind of among the many goals. Two that I wanted to uplift today. One is that I think clinical education is so important in legal education, understanding curriculum, because it offers an opportunity for students to better understand what legal practice actually is and how the legal system and other related structures of power and governance actually work in real people's lives. And I think there's no better way to do that than to actually get out in the community and hear from folks and to be interacting with people in a very proximate way. The second is that I think that clinical legal education helps students move within that system with greater clarity and purpose. So if we're doing our jobs right, students will come out of their experience in clinic with a better sense of who they are and how they want to confront the very real challenges of working within the legal system. And I think on both these fronts, critical race theory overcomes with some risk in incorporating it explicitly in a curriculum in clinic, as Erica said, has a lot to offer. I think bringing critical race theory into clinic explicitly with the opportunity for reflection in a setting where the goal is not necessarily like mastery of the concepts, but more problem solving and thinking through how the concepts can be useful, allows students to be able to engage with theory and practice in a more synthetic way. In law school, we tend to think of these things as separate, but I think in practice, again, if we're doing our jobs right, students will be able to actually integrate these things. And so I have started the project of introducing CRT into my clinic more explicitly. It's still a work in progress, and I think that I've learned a couple of things. One, it is important to do whether it's a boot camp or some other form, to actually give students the foundational readings and not just summarize or talk about it organically, but to spend some time actually introducing it. But second, as clinicians, we have to be willing to respond to real world conditions, which are often messy, and so sometimes that means throwing out or rewriting the lesson plan for the day. And it often requires something that is hard for me, which is to be have control over what I think students should and can learn in a particular day. So the example I'm going to talk about, I'll say just a word about our clinic, even when it was the immigrant rights clinic, is that we embraced multiple modes of advocacy, but one model that we emphasize is movement lawyering, and that's very much thanks to my colleague Samir. And what that looks like concretely when we litigate cases is that we closely collaborate with organizers to ensure that litigation is serving movement goals at different points of the litigation process, and that operating under this model sometimes means different decisions about claims that you bring, about the way that you litigate the case, as Erica said, about what you put in your documents, but also what you do outside of the courtroom, or just a different process for arriving at decisions, involving more people in the room when those decisions are made. And working sometimes with organizational plaintiffs to build leadership within the organization or help them do fundraising or build their infrastructure so that they can be more meaningful partners in the litigation. So the example I'm going to talk about with all that very long lead up is one that is a case that our clinic is litigating that is more in the public domain, and it's because it's, doesn't require so much technical knowledge of immigration law, is the Vasquez-Perdomo case. Bob has heard a little bit about this, and I'm not going to spend too much time talking about the case, but it's challenged the immigration rates in Southern California throughout this summer. It was originally a habeas case, and then we amended it into a class action with individual organizational plaintiffs. People know that on September 8th, the Supreme Court stayed a TRO that the district court granted over the summer. That decision was not unexpected, but it was devastating for all of us, including our students who were working on the case, have been working on the case for a few weeks at that point. And, I'm not going to describe in detail, in part because it's painful, the concurring opinion of Justice Kavanaugh, but for these purposes, in addition to greenlighting stops and racial profiling, I just want to point out that the concurring opinion parroted a claim that the government did not make below. The government below argued that they were not engaged in racial profiling, but by the time they were before the court, the claim they made was that effectively because of the demographics of a city like Los Angeles, you're close to reasonable suspicion just by being in the city of Los Angeles. And so if you add race on top of that, or add any other factors on top of that, you surely have exceeded, the low standard of reasonable suspicion required to justify a police stop or an immigration stop in this case. The decision, the concurring opinion did other things. But one other thing I'll point out is that it really reading it is impossible to square that decision with the things the court has said about the role of race in other contexts. After the decision came out, it was a decision that came out on Monday, and Samir and I, we had some students working on the case as well, decided that we were going to throw out the lesson plan and devote Thursday to a kind of processing class with our students. Many of our students are BIPOC, majority are BIPOC, and we, organized a session with some attorneys involved in the case who are processing it in real time. And then we also assigned Crenshaw's seminal piece on race reform and retrenchment to try to understand this decision in a broader context, to see it as not just something happening in 2005, but part of a broader struggle for racial justice, and to understand why, in the same case, the government could argue that they were not engaged in racial profiling and that racial profiling was okay, and understand that that's actually part of, those are not two separate ideologies, they're part of the same ideology, part of the same game. And so for students, it's important to be prepared to respond to both and see them as, part of a whole. And that piece also helped students to understand that, of course, engagement with liberalism and rights-based advocacy is so fraught that the gains are ephemeral, of course, but to recognize the engagement of that as a tool of necessity that can result in some, at least temporary material gains that are important to fight for. And I think one thing that's a little bit lost in the public dialogue about the case is that, Crenshaw talks about the project of anti-discrimination is not just a rejection of white supremacy and the law, but a commitment to examining outcomes and actual material conditions. And I think the decision is not, Kavanaugh's concurring opinion doesn't just talk about race, it talks about the permissibility of profiling people based on being a low-wage worker, of being, at a car wash, of being in a Latino neighborhood. And so these things are very intimately tied with race and our construction and understanding of race. The last thing I'll say, because I know my time is up, is that we also assigned Doug Allen's piece about discussion of Bell's Chronicle of the Space Traders. And the reason we did that is because they present, of course, a very bleak but important story. But they explicitly say that the ending is not open. And so it is important to understand that, you know, our understandings or the dominant narrative about social progress is both illusory, but that the ending is not yet open. So it is important for our students to feel like there is a possibility of a future while recognizing the reality of the present and not kind of a mythical reality and understanding social progress. Thanks.
My name is Amber Baylor. I'm very glad to be here and have the opportunity to spend time with folks on this panel. I teach in a criminal defense clinic at Columbia, and in the clinic we do both individual representation, so we represent people who are charged with misdemeanors, and then we also do some project-based policy work for reference organizations in the city. So that is the sort of the substance of the field work that the students do. I will say that it's been critical to incorporate the work that people have done in CRT to give students language to understand language that reflects and aligns with what they see in doing the work that they do. So one of the pieces that we have students read at the outset is Dorothy Roberts' piece on order, maintenance, policing. And it's, I think, a critical foundational piece to have students absorb before going into arraignments, right? Where what they are seeing is something very different than what has been described, how the system has been described in their core courses that haven't had those critical perspectives. I also just have a quick anecdote. One of the pieces on the syllabus for the very start of the semester I stole from Erica's Critical Race Clinic syllabus, and it's Julie Lawton's piece, and my client too. Students love the piece. I was at a training this summer. I had a former student who was also at the training. Somebody asked a question in the training, and I saw the former student run over to the person who had asked this broader question in the training. The person was asking me about being a black person, representing black people, positionality, and all those things. And I saw her afterwards, and she's like, "Oh, I told him he had to read this piece," and my student too. So I think that opening of experiencing practice of figuring out your position is also a right place and the right place for students to be supported and be fed by the work that's been done for the course here. So the thing that I'm going to describe as my example is sort of the work, or sorry, the framework that we use for the framework that I use for lawyering in the criminal defense clinic, and how I've worked with others in a way that sort of critiques that framework and broadens it through more explicit application of some of the tenets of critical race theory. So the work that, the framework that I use as a central framework in the clinic is a collaborative lawyering framework. And so I think that it's one that allows us to do a few things. It allows students to interrogate a position. It allows them to think about who they turn to for expertise. It puts on them sort of the burden of making sure that the work that they're doing is collaborative and aligned, and being accountable to alignment in their work. And so we talk about the critical race framework, or sorry, the collaborative learning framework in our initial classes in the clinic. I have a colleague that works in a different course in the law school, who has begun doing a lot of work on trauma-informed lawyering from the position of a person who has been impacted by the legal system. So thinking about how we learn about trauma-informed lawyering and advocating that we learn more about trauma-informed lawyering from people who are in this position, who have been impacted. So he's somebody who's been formerly incarcerated, but also has done work in this space and is trying to build out opportunities for people who do work in this space but also have those experiences to be integrated into the trauma-informed learning frameworks. So he came and we talked about collaborative learning, and one of the things that he pointed out was that without an analysis of how the legal system has created traumatized experiences, has impacted people, that the collaborative learning framework that I laid out for students was aspirational, but wasn't, it was lacking. And so that began a conversation and a collaboration with work that he was doing. His name is Alejo Rodriguez. He's also working with Susan Stern. And so it became a collaboration between the work that they were doing and trying to build out opportunities for people who both had experiences and were doing work in trauma awareness to be a part of what we were teaching students and integrating into the work that we were teaching students. I think of this as an explicit application of CRT, in that it forces not just this idea of collaborative learning without some deeper digging into how people come into the relationship and in the work that we're doing. It forces an analysis of the systemic impact of the legal system on racialized people. It encourages and pushes forward gathering of information from people who have experienced it, narrative-based learning, and then also challenging some of the more neutral settings that we talk about trauma-informed learning. So part of the collaboration is building out more opportunities to have students think about trauma-informed learning and how it intersects with collaborative learning, and to learn about the importance of hearing about the impacts of trauma for people who have experienced it. We did have already a carve-out for, we had a program within the clinics, a week, a workshop within the clinics in which we focused on trauma-informed learning. We had a practitioner come in and do a morning-long session with students, which was wonderful. She was great. But in addition to that, Alejo and I planned for additional learning opportunities for students to hear about how people may be impacted by systems and how that was critical to the work, to the collaborative learning framework that I was pushing for. I think some of the difficulties in the collaboration are in trying to incorporate some of the new framework around trauma-informed learning within the collaborative learning experience was we were asking students to really be attentive to a layering of frameworks. So not just being a trauma-informed lawyer, not just being a lawyer who was thinking collaboratively, but in trying to do both of those things. And sometimes for students, I think that potentially led to a feeling of overwhelm. We also we put together a workshop, 3 series of classes. We held it, as I told the group, on a Friday morning, so it was not as well attended as we'd hoped. But what we tried to integrate into the class were films, which included films that Alejo had done as a person who's incarcerated. We invited guest trauma program directors and also guests who had been impacted, but were also working on trauma or healing justice initiatives. I think some of the benefits of the work were that I think having the explicit intention opened my eyes to the ways that I had, I guess, not been fully thoughtful about how we taught students about trauma-informed learning and whether or not we were sufficiently discouraging students from more pathologized thinking and whether or not we were redirecting attention towards systemic sources and how we learned about systemic sources. And I also think that it was reflected in the work that students did. So some of the work, in addition to representing people, one project was on legislation, developing alternatives to student discipline. And so I think it was a potent shift to, instead of sort of thinking about sussing out individualized symptoms of trauma, which is sometimes how the trauma-informed learning flowed, students were attentive to systemic factors, which I think sometimes even resonated with their own experiences and how they and their families have been impacted by the system, or how they were impacted as in the lawyering role. For students going into direct service, I think this is was a useful broadening of how they viewed the scope of their work and learning frameworks. But I also think it is helpful for students who are not going to direct service work, particularly students who are also going into some forms of policy or other realms where they have the opportunity to think about the systems as well. It's still a developing project. We've sought funding to have more people with these experiences be able to participate in the clinics. Maybe we'll try a different day for the workshop. So it's still very much in process, but one example of thinking about
Brown, and I teach a housing and environmental justice clinic at Fordham. And I want to start by saying that I want to share my time with my clients. So I'm going to start by introducing you to some of my clients. And I'm going to lift up Zuleila Velasquez and Sade Gill Frederick and Mike and Alicia Citron, all of whom are residents at the Jacob Reese Houses, which is a NYCHA-owned project. It sits in Alphabet City on the Hudson River. And these families and hundreds of others have been literally fighting for their lives since about 2022. And this is some of their story.
that water warning at a NYCHA complex in the East Village. The city is now giving out bottled water to the people who live there after the discovery of arsenic in the tap water.
Tenants here say they got word from NYCHA around 7 o'clock last night that arsenic was found in the water. One woman says she noticed the water was cloudy back on August 2nd while changing the water in her fish tank, and as soon as she put the fish back in, it died. She tells me she called NYCHA the next day to complain. They sent a representative out, but she was advised the water was fine. Mayor Eric Adams says NYCHA started testing immediately after getting multiple complaints of cloudy water in early August. Now, out of the abundance of caution, tenants here at Jacob Reese houses are being cautioned not to drink or cook with a tap in their apartment until it is deemed safe to do so.
So this water is for drinking. That water over there is for my dishes and to take a bath. You see the water already set up for the bath. So we brush our teeth, hair, everything with that. And I have to have water in the window for my medical condition.
Elderly dementia patients have increased risk of death or stroke. Employment is not improved for dementia-related sectors.
And it's sort of kind of depressing because it's the USA, you know what I'm saying? And I'm a citizen and I worked hard all my life, you know what I mean? And it sort of kind of feels like you're being picked on in a way because you're disabled and you can't work and you don't have the money. And this is what I'm boiled down to. For about, I would say, a year and a half of me being here, the hot water was just cold. And they kept saying, we're fixing the pipes, we're fixing the pipes, we're fixing the pipes. Now we fast forward to 2022, where Con Edison admits that the pipes were built in 1912 and need to be replaced. So you would think that all that work they're doing out there is that's what they're doing. That's not what they're doing. They're just doing a patchy job, which is not going to last long. And we still have contaminated soil. So when the wind blows, you know, all that stuff, God forbid you outside. That's why so many people are sick. So many people have headaches. They don't know why. People can't. There's just so many illnesses unexplained. But when you sit down and think about it and pay attention to our just this little square area environment, it makes sense.
So this is just a few minutes of 50 hours of video that a filmmaker, Aiden Elias, has been taking, walking everywhere with the residents of Reese since this time to try to document what their lives are like. And I just met the tenants of Reese about a year and a half. They didn't have any representation. This was them organizing and trying to do what they could on their own. And so what I want to talk to you about, I teach CRT in my clinic, and I try to teach the students, the tenants, but I want to talk today about counter-narrative storytelling. And I see what Jacob Reese tenants are doing and what I hope that the clinic is helping them do is push against the narrative that has been put out by the city, by the state, by NYCHA, even by the media. After this news report that you all saw, Eric Adams came to the complex and drank the water. This was before we all knew that he was a felon. And
dropped it.
yeah, and he said, if I drink it, it must be safe. And really, the media just went away after that. You know, if the mayor comes and drinks water with a bunch of news cameras and says that the water is safe, then the water must be safe. But all of the people who I met there, they have cancer, they have spots, their hair is falling out, teeth are falling out. Some people have died, young people have died, older people have died, pets are dying. there's no way that this water and this air is clean no matter what Eric Adams says. And so I think there's a role, I mean, storytelling is not new, but I think what CRT urges us to do is use storytelling as a tool in litigation, right? And Aiden, even before his 50 hours of footage, is not a lawyer. So what we've done is try to come in and say additional people that we need to interview, because we understand claims, we understand the case that we're trying to build. We're working with a group of people who are very organized, who are very powerful on their own. And I just want to say we're just adding to that power. I think of us as adding to the power that the community already had tried to build for itself, and trying to bring legal tools to their storytelling, a legal lens to their counter-narrative storytelling. And so I just want to remind us what the work of counter-storytelling and litigation is to magnify the stories and experiences of underprivileged communities for the purpose of excavating truth. And we heard about truth earlier today, but truth in this case, I feel like what the clinic brings is truth to change their circumstances, not just storytelling for the purpose of storytelling, which has some inherent value, but storytelling for the purpose of change. And then we cognize a different kind of knowledge production through helping our clients tell their stories that foregrounds the experience and expertise of the minoritized. And populations that are living through harm as opposed to having been harmed. What I see as our role in trying to use counter-narrative storytelling in this modality is to say that we can use this narrative to interrupt the harm, to intervene in the harm, and hopefully change the course. And then finally, I think that this seeks to reconsider the impact that power has on the law. Again, like media is owned by power, and that we can use counter-narrative storytelling to try to counteract the power that the media and the state have and are using against our clients. So I'm trying to teach the students to do this work by also giving them some tools that bring traditional clinical pedagogy together with critical race theory to build a framework that helps them see how to guide themselves and their clients forward. So I can build that with Richard Delgado's storytelling for oppositionists and others, but add Alexi and Jim Freeman's It's All About Power, Not Policy and Movement, War and Peace. If I have them read those together, I think that the literature becomes more full. Or Mary Masuda's Looking to the Bottom, Critical Legal Studies and Reparations, and also Carolyn Gross and Margaret Berry's work on narrative, so that we don't just bring forward the clinical legal pedagogy, which Erica named. I see that as rich as it is missing something without also adding the critical race theory to it. So my time is up. I just want to say, I try to do this so we've hired a filmmaker of our own, David Simpson, who's an adjunct in my clinic now, and who's working with us and teaching my students and Aiden, and we're trying to build a legal storytelling, a critical race legal storytelling kind of pedagogy inside the clinic. One way that I've done it is by hiring David Simpson, but another way that I've done that is trying to work with the Moth, which is a storytelling workshop in New York City. They have a podcast. So I want not just my clinic as associate dean, I think I have right now the power to bring this to all the students. So for orientation, the Moth came and did a workshop with all my students in the entire clinical program. And we started to think about storytelling, legal storytelling, critical race storytelling. Ian Weinstein and Liz Cooper taught from the perspective of the clinical theorist, right? And then we layered with the Moth how counter-narrative storytelling can intervene in problems that our clients are facing. But trying to push that work even further, now we're going to have the Moth teachers who are with us from orientation come back, and they're going to do a one-credit clinic add-on with students and clients to help us further deepen our storytelling and counter-narrative storytelling kind of toolkit. And I do this to try to, and Donna is in the room, and we've been thinking about decolonizing the classroom for 3 or 4 years together, and I see the opportunity to bring the MOF workshop leaders in as teachers and our clients into the classroom along with our students, and try to help us all think together about how we can better use counter-narrative storytelling to intervene in our clients' problems as a way of trying to spread the work of not only CRT, but particularly counter-narrative storytelling as a litigation tool beyond even just my clinic, but through the whole entire clinical program. So I'll stop there, and I look forward to having a conversation with you.
So, just so we can move to our experiential portion of the workshop, I'm just going to throw out a couple of things. I'll throw out an idea that I'm taking from Samir Asher, whose name's already been invoked a couple of times today. But I'll throw out that idea, and I'll give you an example of where I think we have done. I'm going to talk a little bit about what is prefigurative work in the clinical space, and which is Samir's idea, not mine. And then an example of where I think we've done that, and then we can just move quickly into the experiential portion. So Samir has written this great article about the way that clinics are an excellent space for prefigurative thinking. And prefigurative thinking he's defining as the way we produce and understand knowledge outside the terms and constraints of our current law or our current moments, right? And so if we think about that, community organizations and social movements, they don't just develop policy platforms and think about ways to change the law. They're also really pushing us to experiment with different forms of legal advocacy, different forms of institution building, for the purposes of meeting human needs, and to resist, and in that process, resisting liberal co-optation of their struggles and of movements, right? And so I found this concept very informative because, as my co-panelists were helping me to understand when we were talking about this, a lot of the work that we're doing in our clinic, and I know Jeannie Nishimoto is here, she co-teaches with me. I teach, I guess I should say this first, I teach a veterans justice clinic, and so we ultimately represent almost all homeless or housing insecure veterans who seek medical services from the West LA VA campus, where UCLA doctors are most of the providers, right? So there's a collaboration between the VA and UCLA to prop up this clinic. And it's really uniquely situated because we're in a low-income community. So it's like, imagine a law office in, a HUD housing community or in a NYCHA community. So we're embedded lawyers. So there's lots of different choices and decisions that Jeannie is making every day as the person who's running the office. But when we come together to teach our students, we do the teaching from the perspective of, we use the pillars diagram as a foundational tool from the Birth of Justice Institute, which is saying that, look, if the goal of movement lawyers or social justice lawyering is to help communities build a base of power, how do we as lawyers and in a legal project relate to that project? So we think about 3 pillars: policy advocacy, legal services, and litigation, in relationship to that goal, that social change theory, that goal of social change. And I would say we don't, as a clinic, we do a lot of, or Jeannie and our staff attorneys do a lot of high volume legal services, so we're not necessarily working towards that goal given our mission. However, for the students, it's really instructive to think about lawyering in these frames. And so the place where we bring in more of sort of a more traditional idea of movement lawyering or social justice work is in our projects. So the prefigurative, the place where we last year we shifted our clinic. Talk about making change at the last minute. We decided days before the semester started in January to shift to just scrap the whole thing and start over and do wildfire work on disaster response, because Los Angeles was hit with devastating wildfires. It changed the legal landscape for everyone. And so we, through our partnerships in the community, started working with a couple of groups that just kind of propped up overnight, really, to figure out how to help the community in Altadena, which is sort of historically Black home-owning community, keep the land and keep the properties within the community control. And so, because we know disaster capitalism, we know disaster speculation, people were going to come in and try to buy up property while people were very vulnerable. Not just Black community, this is not just a Black community, but intergenerational, so there's lots of elderly folks, there's people with disabilities. So we knew that there was going to be this crisis, and we knew that there needed, and I think the legal community here was well positioned to learn from already had relationships, and we're learning from what happened after the Maui fires, what happened in Katrina, and responded immediately to say we not just need to do legal services clinics and do FEMA appeals and all of those things that people really need to deal with their material conditions, but also what are literally the structures that we can create for land banking or land trusts or community development trusts. Like, I don't know, all these things I don't know anything about because I'm not a land use attorney or an urban planner at all. And so all of our students worked on this project, which is a challenge in and of itself to get all the students organized for one thing. But we got IRB and did interviews of directly affected folks basically the group was coming together to do legal research for advocacy at the local and the state level. And so our research, I think, informed those policy decisions, and then there was a series of reports that were put out that we assisted and supported. So we did qualitative IRB research that they wanted to be able to cite. UCLA researchers did this study, and then we did direct services pop-up clinics, so the students would get to know the legal issues and hear from people directly. And then we also, I feel like we did more than that. I don't really know, but we had a really interesting, series of conversations. The application of CRT being not just counter-narrative storytelling, but also in this idea of prefigurative thinking, where you're thinking about what is the future, what does the community want in the future, and what legal tools can we use to try to envision that future. So a future that is still majority Black-owned property, a future that is still, the uniqueness of the Altadena community. It's an arts community, intergenerational, Black wealth, like all of these things that are hard fought. And there's a whole history of like redlining in Los Angeles and like all of these things that kind of come together around us. So the students had to learn about that, they had to understand the dynamics. Why were we doing this with the Altadena community and not necessarily the Palisades fire? Like there were all these questions and things we needed to think through from a racial justice lens. And so I found Samir's article very instructive in thinking about the way we do our projects, because this is one of our projects we've done several projects around alternatives to policing, again, kind of a prefigurative project, because we're working with communities around envisioning a different way of thinking about public safety. And so, anyway, I just want to say I learned something in preparation of this panel, a different way of thinking about our work. So, thank you.
You want to share the prompt? Okay, so I think what we're going to do is we have about 20 minutes left in the session. We do want to reserve maybe about 10 minutes for like Q&A if anyone wants to raise something, remarks to Bart. But we also want, if you're willing, to engage you in an activity. So it's really just a very simple prompt that will ask you to free-write and then maybe pair and share. Take a few minutes to pair and share. So there are two options. because people are differently situated. Just pick whatever feels like it fits, you know, that you would like to try it on better for you. So the first is, you know, how have you integrated CRT principles into the work you do, or if you want to more concretely think of a case or project that you've either worked on or read about, and how you can see CRT principles being integrated into that work. And then the second option is identify, easier, identify something that you're currently struggling with in practice or in your work, and what might CRT have to offer. There are kind of different ways of thinking about the same question, but take, it's going to feel kind of quick, maybe take 90 seconds to think about it. This is just to get your juices flowing, and then we want you to turn to someone next to you and just share some preliminary thoughts.
So feel free to turn to the person next to you whenever you feel like you have an idea.
Sharing, we want to give a little bit of opportunity to see if anyone felt like their parent share was so generative that we should all be involved so that we too can grow from what you just theorized. So if anyone has anything they want to share, we're open to that. We want to give space for that.
That's okay. I will share. Also, have a question for you.
Yeah, and then we're going to
course.
yes,
And we
sure.
can do that.
And
Yes.
we can do that.
Yeah. Well, we talked about this case. Remember actually your case and how we could use CRT in that case. And I was saying how in similar cases that I have in my clinic, I teach a movement wherein clinic, but I teach a lot of CRT in the clinic as technique as well and method. And when we create the fact section for a complaint, I tell them to always discuss the context and to do so by documenting the racial dynamics of the community, and particularly in a case like this or in cases like I've been involved in, explaining the history. I think similar to what Erica said, explaining the history and how the case would not have played out the same without those racial dynamics. And you can't understand both the harm or even think of an accurate remedy. So for example, in this situation, we're saying that not only should they have the pipes fixed, but also they should think about reparations.
Yeah.
They've got health issues, cancer, and some of that is just a remedy, but thinking about taking a step back and looking at how these people's lives have been impacted intergenerationally because of race and economics. And John Calmore talked about that in his article called The Context, about how you have to look at racialized spaces as sites of identity formation and how that plays a role in how you advocate, how you can create a story about their community that speaks to what would be justice for their community, not just individual people in the building, but a story about the entire community that would allow there to be a communal remedy. But my question for you though was, how do you get? I said all this great stuff, but the truth is, when I teach it in the clinic, I think like you had gestured to, Erica, sometimes you go through all these different critical race theory concepts, then when they get to the cases, they just want to just do the bare minimum, just like, just do the black letter law, and you got to sort of keep pulling, like really emphasizing the critical race theory aspects or the movement lawyering aspect of the work. And there's this impulse to just want to do the actual work in a silo from the critical race theory concepts that you're teaching.
Yeah.
So what is, how do you bridge that? Is it just you have to find a way to try to grade them on their use of the concepts, or what is the way that you bridge that gap?
Thank you for all of that. I just want to respond first to your reflections about kind of what you do. We're about to round this week on remedies, actually, and one of my efforts to like break down the classroom walls is to bring Zule, who's the president of Students Association, into that class session and to think about remedies together. And the students have been working with her in advance to prepare for rounds together so that she can understand like what we would be thinking about as remedies, and so that the students can understand what she would be thinking about as remedies before we bring the whole class into the conversation. I think that she's going to be like where they might not think of reparations. I think Zule's going to be all over, you know, the concept, and even if she doesn't use that exact word, that she has that in her frame. And so I would just offer back to you that I think that the more we're bringing, instead of having our clients on the sidelines and bringing our clients into the conversation and into the classroom and into the meetings, I feel like it helps the students, because what they might resist from us, I feel like it's harder to resist from the client when the client is in the room. And so I think that may be kind of an answer to your question. I'm saying this back to you in response to your comments, but I also think it's an answer to your question, because I think the students can maybe the clients are so compelling, right? What they've been through. Our clients don't want to meet with us so that, you know, we have the traditional client thing, like go meet the clients where you are. But they are very hesitant to have us to come because they don't want us to get sick. They'll say, no, don't come. We don't want you to be, no more people need to be exposed to this. And so like they're just such compassionate, good, wonderful people. Like it's hard to think like, oh, we should just stay in this box or that box. After you've seen, I think what, so Con Ed is now fixing it, right? But no one talks about the people. No one talks about the illness. It's like, it's all just property. And so I've been loving all this property conversations since we've been here, because it's just like, oh, the land, you have to fix the buildings, we'll sit with the people. And I'll just say one more thing, like my students start to, I don't name everything as explicitly as Erica does. Maybe that's not great, but I just kind of go with it. So if I'm teaching the Fair Housing Act or Title VI or Title, you know, like I can talk about critical race theory in the same way. I just like would bring it all in without having to make hard stops, I guess is what I'm saying. So I'll invoke one and the other. The theory is all doctrinal to me, and so I don't think about the critical race theory as not doctrinal, but the FHA as doctrinal. I don't make those hard distinctions. I kind of flow with it a little more. And I just think too, in thinking about young people right now, they know more than we did. Like I never thought about intersectionality when I was in law school. I mean, this is or at the Department of Justice, and I did a lot of cases that if we had had that frame, it would have made things much easier to think about instead of kind of getting to their after 2 years, you know. But the students, I was trying to talk to them about the difference between environmental law and environmental justice for the hardcore environmentalists. And sometimes they don't see, like they're a little bit confused, like why are we doing this? We could be hugging the trees. And you know, they were like, oh, it's ecocentric versus human-centric. And then one of my students were like, you know, it's really intersectional. Like the humans and the earth are like at an intersection. And I thought, like, I didn't have to say anything, you know, like they get it. And so I think the more we just put it into the discourse, and they getting it in the discourse, we don't have to like have a unit necessarily all the time. I'm at a place where the unit might not work. That's one of the reasons why I do it. So, anyone else had a generative? Really, thank you for the conversation. Want to add? Want to add?
Oh no, I'm just stretching.
Okay, that's good too. That's what your body needs. Yes.
Questions?
Do you have more questions for any of us, or thoughts, or this come up in your work too? Or we're all waiting for the main event. Suitcases about to moderate the main events.
Thank you. Seriously, always.
We don't want to have to be.
Yeah. I'll add my perspective. So I'm a 1L student here, and I think I don't necessarily have a question, just like comments in general. And it's like it's amazing to see you all doing the work, and like definitely as a student here, I feel very privileged to have like CRS and have a lot of. I mean, like the difference between my professors who are like associated with the CRS department and versus those who aren't, like it's, at least to me, it's very clear in terms of like, you know, how they frame it in terms of what's happening in the real world right now. And just having professors and faculty here just like encourage me to think very critically of a lot of the cases that I'm reading that can be rather mundane sometimes. Whether it be contracts or torts or even civil procedure, and being able to like kind of be encouraged to take that critical lens is really awesome. So it's amazing to hear all the work that you all are doing at other schools as well. And I hope you also are having, I know you're having that same impact on all your students.
Oh, that's really cool. Thank you.
I do, sorry. I just want to preface by saying I'm not a law student. I am in a process of applying, so.
Great.
Thank you. Earlier this morning, I was moved by the conversation in the preliminary session regarding what is truth. And for you, Professor Brown, you're talking about this art of storytelling as making that move. I see that as a way of doing that, but I'm also curious in how you get to use these clinical sessions as a way of exposing those truths to your students so that you do get more of the buy-in and that it's not such of a pulling teeth to get them to think about these things using the CRT lens.
Again, my clients sometimes show up with bottles of dirty water, and I just feel like again when they speak, it's just really hard to ignore. It's hard for the students to ignore, and that's not the only case. Like I represent a gay man of color who's HIV positive in a building that gets a subsidy to house people who are in that same, but they harass the hell out of them to try, they get tax breaks, but so we at one point represented 4 gay men of color who live in this one building in Hell's Kitchen, which is supposed to be safe space. If you know anything about New York, Hell's Kitchen is the safe space, and gentrification is making people who are like heteronormative, right? Like you just feel like you can take everything, and when you see what people are going through, it's hard to not see and use this lens to see like what truth really is, and so I guess I would just say that like the story again, like listening to our clients and foregrounding the stories of the minoritized and the oppressed, I found to be very compelling for my students.
Oh, I know we're over them, but I was just going to share in terms of the generative conversation when we talked about narrative, that sometimes the narrative is the point, right? And it's not, and we can use the law as a tool. And so we shared about how an amicus brief that Shalene is working on will just share the narratives of folks who are challenging the trans ban military service. And that it's just the narratives, yet they will not be included in the briefs, and I use just in scare quotes because it is so significant. And combining option 1 and 2, I shared the fact that, and I should say, my name is Liliana, share her pronouns. I teach at a racial justice law clinic at the University of Minnesota Law School, and good to see you. But, so something that I've been struggling with is that I work on an information request case where I have clinical colleagues who don't use critical race theory notions and will say, oh, this is just an information request case, right? Or that value certain types of practice or certain kinds of modes of lawyering where the just
the information request case that we're working on is for a black woman whose black male fiance was presumably murdered by the St. Paul Police Department in 2009, and we were seeking video evidence, right? And so just but this isn't the substantive case, or it's not the wrongful death case. And so sometimes struggling even with colleagues, right, within clinical spaces who don't necessarily view this work with the same frames that we do. But so integrating CRT into this particular case or project, the defendants in this particular case, the city of St. Paul and Hennepin County, they've talked to us about the same idea. It's not the wrongful death case, so, like, we're not going to be settling this for, big bucks. Like, wait, maybe they don't want to take the time to hear our client. So we were able to force, basically, a mediation where, again, we knew that they were never going to offer any, some true, and they literally said no more than a nuisance fee, right? And so what it means to even imply that she's a nuisance, or that this is a nuisance, or it's a waste of time, going back to the just. But out of that, we were able to force mediation where our client got to share her experience of trying to get the video and of the night that her fiance was stopped and found dead, and shared for 2 hours, right? Like, so the city had to listen to her for 2 hours. And that in itself, we talked through as a class, right? How that's the point in many ways. And not, did we settle, did we get, that's not that.
We have come to our time. Thank you so much for sharing.